Good afternoon. My name is Brian Butler, and I am a Chicago Regional Director with Lieberman Management Services. On behalf of LMS, I would like to thank each of you for dedicating your time today to join us for our educational webinar training session. This session covers important matters related to your service as an association board member. Joining us today as our featured presenter is Howard Dakoff. Howard Dakoff is a partner heading the Community Associations Practice Group of Levenfeld Pearlstein, LLC. He concentrates his practice in condominium, real estate, and general corporate law. Howard is the co-author of the current chapter on condominium management for the condominium law textbook published by the Illinois Institute for Continuing Legal Education. Howard also regularly publishes articles on a variety of community association topics and lectures extensively at state and national seminars, and is an elected member to the College of Community Association Lawyers of the Community Associations Institute. You may recognize Howard's name as the weekly columnist for the Chicago Tribune, Sunday edition, as the Condo Advisor. And with that, I'll pass it over to Howard Dakoff.
Hello, everybody. Welcome from all reaches of Chicago and the surrounding suburban areas. It's my pleasure to be with you this afternoon for a condo board member boot camp. And today we're going to give you some of the nuts and bolts on understanding your responsibilities as a board member and just explaining some of the best practices for boards and some of the law that you should be aware of to understand your service. So let's just jump right in and get going. So as you can see here on this first slide, this is a ladder. And the ladder at the top is the primary. That is your Bible, if you will, of condominium law. There's a hierarchy of governing documents, of which documents control over which documents. The Condo Act, the statutes, and the Illinois Not-for-Profit Corporation Act will always trump any declaration and bylaws provisions, just like any declaration and bylaws provisions are going to trump rules and regulations. These are the three areas that you need to understand in terms of if any of the lower documents are inconsistent with the higher document, the lower document is moot. So your condo declaration. This is the single most important document that creates the condominium regime, and it outlines the responsibilities of board members and the unit owners and the association. So what's contained in a declaration? Very common question. All declarations more or less have the same general structure. There's going to be a definition of terms. It's going to outline easements, rights. It's going to outline maintenance, repair, and replacement responsibilities. Most of the time it could be the association for common elements. For some limited common elements, it could be the unit owners, but it could be the board. And for units, it's always going to be the unit owner. You're going to also have unit percentages is going to always be an exhibit to every condominium declaration. That tells the association how much interest you own of the common elements. And what does that mean? That means that your assessments are based upon your percentage interest. Your voting power is based upon your percentage interest. How can declarations be amended? Only through a unit owner vote. There will be a provision in every condominium declaration that has the minimum requirements to amend that governing document. Section 27 of the Illinois Condominium Property Act has to be read in conjunction with that because sometimes with older declarations we see amendment provisions which are inconsistent with state law. So for instance, state law says that no more than 75% and no less than 66 2/3% of the unit owners can be required to amend the governing documents. So if you live in an older condominium, you may have a condominium declaration that says it requires 80% to amend your governing documents. That's inconsistent with the Condo Act, and thus it would be reduced to 75%. The bylaws. The bylaws are in one of two places in a condominium declaration. Most of the time, they're attached as an exhibit to the condominium declaration. But quite frequently, and increasingly, they're just incorporated in the body of the declaration. The bylaws are slightly different than the declaration. They're just as binding, but they contain provisions on how the association is administered. It has the procedures and composition of the board. It has quorum requirements. It will have notice requirements. It will describe the size of the board and when the election will occur, etc. The next set of documents that will govern your association are rules and regulations. These are requirements or rules that are adopted by the board. So whereas every purchaser of a condominium unit purchases their unit to an existing condominium declaration and bylaws, the rules are adopted by the board at any time. They can be rescinded by the board at any time, and they can be modified by the board at any time. The only requirement is that proper notice be given. That notice is to send out any revisions or new rules no less than 10, no more than 30 days before the board intends to adopt a rule. It's a unit owner meeting first, where the unit owners have an opportunity to comment on the rules. That unit owner meeting is adjourned, and then a board meeting is called, usually immediately thereafter, and then the board can vote by simple majority of quorum to approve the rules. Rules cannot be inconsistent with the declaration and bylaws, and if you recall from that first slide, the rules are at the bottom of the hierarchy. So the board. What is the board? The board, no different than our elected government, they're elected by the unit owners to represent and make decisions on behalf of the association. And so what will the board do? The primary responsibility of the board is to really administer the condominium association. And that takes the form of maintaining, repair, and replacing the common elements. There's a variety of other requirements in all declaration and bylaws and Section 18 of the Condominium Act, which has the minimum requirements for bylaws. But the most important things that for this basic Condo 101 is that board members need to understand that they have fiduciary obligations to the unit owners and that a board must meet a minimum of 4 times per year. Fiduciary duties in the law. So as an attorney who specializes in community association law, one of the areas that we get a lot of questions, especially for new board members or first-time board members, is to understand, what does a fiduciary duty mean? I hear that term thrown about at seminars, trade shows. My management company will say it, but what does it mean? And so the next few slides are going to be a summary of the highlighted cases here in Illinois and in other jurisdictions that are applicable. And so when someone asks, what is a fiduciary obligation? The most common layperson explanation is you have a legal obligation to look out for the best interests of the association. So what does that mean? Well, that means, number one, you must comply with your governing documents and statute. If your document says you must collect assessments, for instance, and you choose to give a pass to a friend in a unit that's delinquent, that would be a breach of your fiduciary obligations. Similarly, if the Condo Act or the Not-for-Profit Act requires a board to do something and that board intentionally derogates its responsibility, that could be tantamount to a breach of their fiduciary obligations. Number two, if you look at the board of directors of the 175 East Delaware Place Homeowners Association, the board has broad powers to administer and govern day-to-day. Courts inherently defer to condominium, co-op, and community association boards to make the decisions that they feel is best for their community. The board can adopt and rescind and revise rules and regulations, and the board has some wide latitude to interpret its own documents. That's just a general statement of the law. Number three, so when directors ask me, well, when can we be held liable? When, it's always the converse of what I have here as number three. So the statement of law is that directors are not liable for maintenance decision as long as you exercise prudent business judgment. It's called the business judgment rule. So the converse is, when could there be liability? Well, when a board willfully and wantonly makes a bad decision that is beyond all reasonable norms, a court could find that such a decision is not reasonable and thus not prudent business judgment, and there could be liability. Number four, the Robinson case. So this basically says that the board of directors must comply with its obligations of the governing documents in the Act. It's kind of a restatement of the Walensky case, number one. Number five, board liability for breach of fiduciary duty. When will it not exist? If you look at the second half of that, so part one was the reasonable business judgment. But for board members who are not sure in an area or a decision, if a board relies upon advice of professionals, the Palm case gives cover from a breach of fiduciary duty claim. So for instance, if a board thinks they want to do X, Y, and Z, they're not sure if they can do X, Y, and Z, you seek a legal opinion. If you rely on the advice of the legal opinion, whether the opinion is right or wrong, you will not be in breach of your fiduciary obligations. Hopefully your attorney understands this area of the law and the advice is correct, but even if the attorney gave you bad advice and it turned out was the 180-degree opposite of what the opinion says, there may be some liability of the legal firm to recoup at least your legal fees, but you would not be held liable for a breach of fiduciary duty. And so in a post-Palm area, and we're going to talk about the Palm case in a few slides, one of the areas where board members can protect themselves is to seek opinions from professionals. And it doesn't have to just be attorneys. It can be accountants. It can be architects and engineers. Whenever a decision has some significant consequence or clearly a significant financial consequence, it is a good decision for the board to seek outside experts to help the board make the best business decisions for their community. Number 6 is just a restatement of the business judgment rule, but I'm giving you the case. Number 7, there was a case back in 2008, not so long ago, where a board failed to have fraud embezzlement insurance. And of course, this was a situation where a board member had embezzled. So the courts found that the board itself, all the board members, breached their fiduciary obligations for not obtaining the insurance. So Section 12 of the Condominium Act has minimum insurance requirements. Along with your management company, you should make sure through your insurance agent that you have all the required insurance as stated in your condominium declaration and at the minimum requirements of the Condominium Act. There's a variety of other insurance levels that are not required, but good practice, such as workers' compensation insurance. So what can you glean from this, the pure law? What you can glean is you will not be ever held liable, barring any unusual facts, if you make reasonable business decisions and or you rely upon advice of professionals. You have a broad discretion to maintain, repair, and replace your common elements and the decisions that go along with that. Board members will not be liable for mistakes unless it is willful and wanton, otherwise stated as number 3, reckless or blatantly ignore the law. And number 4, common element maintenance, repair, and replacement decisions. They may be subject to a unit owner challenge based on cost, but just because a board approves a costly project does not amount to breach of fiduciary duty. So let's talk and transition a little bit about the board officers. Every board will have a minimum of 3 officers. So on a board, unit owners elect directors. The directors themselves choose officers. The minimum state law requirements require a president, secretary, and treasurer. Some associations, and if yours is one, could have vice president positions as required by the bylaws. Once again, we look to the bylaws for administration requirements. But we're going to talk about the most common 3 officers, which are president, secretary, and treasurer. So what does a president do? Let me tell you what a president doesn't do. The president is not a personal fiefdom of an individual. The president does not make decisions. The board makes decisions. The legal definition, if you look in Section 18 of the Condominium Act, is that the president presides over board and unit owner meetings. That means they call them to order. And the president also can appoint a sergeant-at-arms to have people dismissed from a meeting. Other than that, that is what the legal role of a board president is. So now you can see here I have a bunch of customarities. So what does a board president customarily do? Well, the board as a group can appoint any of these customarily items that I have on the slide to any board member, but traditionally it's the president. So traditionally the president is the point of contact with management. Traditionally the president signs contracts. And traditionally the president is the legal liaison with the lawyer unless the board appoints a different legal liaison. So once again, in order for the president to sign the contract, the president, him or herself, does not make the decision whether or not to sign. That is a board decision at an open board meeting. But customarily, the president will be the officer that signs the contract. So what is the role of board treasurer? The board treasurer, as you would think about as a layperson, generally relates to the finances of the association. Now, for those associations that retain professional management, most of the functions of what would generally be a treasurer responsibility are ultimately delegated to the managing agent as part of the management agreement. The assessments will be collected through the managing agent and be posted to the account ledgers of the managing agent. The vendor invoices will be sent to the managing agent, checks will be written by the managing agent, what have you. The financial statements will be prepared by the managing agent. Nonetheless, the board treasurer should be, at least the board treasurer should be reviewing financial statements. I would proffer to tell you that every board member should review all financial statements. To be an informed board and to fulfill your fiduciary obligations, you need to know how your money is being spent, what financial obligations and liabilities you have, and what assets you have for anticipated expenses. For those expenses that are unanticipated, that's hopefully why you have a reserve fund. So the board treasurer will also be the individual who spearheads the annual budget collaboration with the managing agent to put it to board vote and ultimately to the unit owners. The board treasurer will usually be a financially minded person who will make suggestions or work with the managing agent to invest association funds. And for those times where a board requires the managing agent to list them on a reserve account, it's usually the treasurer. The board secretary. So the board secretary traditionally drafts the meeting minutes. Could that be assigned to another person on the board? Yes. I said the board. I didn't say the managing agent. A lot of boards feel when they retain professional management that it's the management's responsibility to draft the minutes. That's actually not the case. A managing agent could accept that responsibility, but generally they don't because they want the board to document what it believes board action was. The association, the secretary will also maintain records, but I have a caveat. If you have professional management, most of the time the managing agent will be the holder of all the records, financial records, governing documents, copies of contracts. So in a traditional sense, if there's no professional management, the board secretary has a much larger role, so does the board treasurer. But when you have professional management, a lot of these issues are delegated. The board secretary will also attest to signatures and may be a secondary or primary signatory in the reserve account. So what's a best practice? If I had to, for board meetings, I would say there's 5 best practices. The board secretary will draft the minutes, not the managing agent. Minutes. Meeting minutes document decisions. They are not meant to be a resuscitation of everything that is said. Not word for word, not necessarily in essence. They are meant to be an official record of what occurred. Board minutes can be a little bit more colorful and characterize some issues because, as you probably know and I would experience and concur with, you don't always get the highest unit owner participation, and so a board can communicate to its owners through minutes if it's part of their normal process to distribute minutes. Meeting minutes will contain resolutions, and they should document each director's vote. If it's unanimous, you can just write unanimous. If not, there should be a roll call. Board meeting minutes do not include comments from the owner's forum. An owner's forum is meant for unit owners to have dialogue with the board, but it is not part of the official board meeting. It usually occurs before the meeting is called to order, and in some associations it's called after the meeting is adjourned. Illinois law section 19 requires meeting minutes to be kept for at least 7 years. So I wanted to highlight the most basic provisions of the Condo Act that board members should be aware. You can get a copy of the Condo Act by just going to your managing agent or going to Google, typing in Illinois Condominium Property Act, or for a self-plug, you can go to www.lplegal.com, go to our condominium practice, and you can get and download the most current version of the Illinois Condominium Property Act. If you're a community association, you can get the Common Interest Community Association Act. But focusing on condominiums for a moment, because that's really what this particular presentation is, I highlighted the most high-level bird's-eye view of the Condominium Act. And I gave you the specific sections of what relates. So an association will collect assessments. An association will prepare a budget. The Condo Act requires a reserve line item, a reserve fund, unless 2/3 of the owners vote to dispense with the reserve fund. It is never recommended to not have a reserve fund for obvious reason, unexpected expenses. Boards must distribute an annual accounting, so usually in the spring of each year there will be a document. If you're professionally managed, it'll be prepared by your professional management company, and it would give an accounting of income and expenses for the whole year. That must be distributed to owners. Boards must hold open meetings. So there are exceptions. If you want to know what the 3 exceptions are, look at 4A on my slide. They are pending and threatened litigation, employment issues, and assessment or rule violations. Other than that, all discussions and decisions must be made in open session. So what do the owners have a right to? Owners have a right to observe board meetings by law. But you can see they do not have a legal right to participate. If an owner is disrupted, they can be asked to leave. There should always be minutes of open board meetings, but there are not minutes of closed sessions. So in Section 4A, we have the exception of when in a closed session meeting, a discussion could be occurring. You do not take minutes of closed sessions. You only take minutes of open session. However, while a discussion may be in closed session, all votes must be in open session. And letter D here. We're going to talk about the Palm case on another slide. But the boards may not conduct working sessions or email voting. This is straight from the courts here in Illinois from 2014. Section 18.4, this is the section of the Condo Act that deals with the ability to maintain, repair, and replace common elements and the board's authority to do so. Section 19 lists the records that boards must make available to unit owners upon request. There's a category of documents that a unit owner has a right to just by asking, and there's a whole section of documents that a unit owner has a right to only if they state a proper purpose. But don't get too excited. A proper purpose is broadly interpreted, so as long as it's anything intelligible, that would probably meet the standard. Section 12 is the provision of the Condo Act that deals with what the minimum insurance a condominium association must purchase, and it also has some other standards relating to insurance-related issues. And lastly, Section 22.1. This is the section of the Condo Act that requires a disclosure to potential purchasers. I put here a best practice is to approve them at each board meeting, and that is because throughout the year there's going to be purchases, presumably, and hopefully. And as the year goes on, information is going to change, or could change in a 22.1. So in January, the board may think they only have a list of 3 projects, but somehow by May they realize they have 6 projects. Those added projects that were not disclosed maybe at the beginning of the year must be disclosed upon the board's anticipated expenditures. A big misconception, I want to highlight this. If you look at Section 22.1, it's going to talk about a specific disclosure that a board must make to disclose any anticipated expenses in the current or succeeding 2 years. It does not say that a board must disclose only approved projects or approved special assessments. The statute says if the board anticipates that an expenditure will be this year or in the next 2, they need to disclose that. So we put that boards should approve this monthly. So what are the authority of directors, right? So we kind of highlighted the role of the officers. We highlighted the major provisions of the Condo Act in a very high-level sense. So if I had to put it in simple English, what does a board do? They enforce assessments. They coordinate maintenance, repair, and replacement. You have the ability under Section 18.4J to enter units to the extent necessary to protect the common elements or other units. Think of a water leak. You have a legal right as a board to go into a unit if somebody's out of town and the water is coming into the units below. Letter C, the board can raise assessments in a budget in any amount without unit owner consent. There's a caveat. It's not that the owners have consent, but owners have rights to reject under Section 18A8 of the Condo Act. That means if a budget and the special assessments of the previous year increase more than 115%, basically a 15% increase over the previous year's special and regular assessments combined, 20% of the unit owners can initiate a petition, and if they get it signed by a unit percentage 20% and it's delivered to the board within 14 days, the board must call a unit owner meeting where the unit owners, if they get a full majority of the association, that's 50.01%, can reject an expenditure. So boards can adopt a special assessment or raise assessments in any amount, but under certain circumstances, owners have rights to initiate procedures to try and reject special assessments or increase in regular assessments. The board makes broad decisions for maintenance, and unit owner consent is not allowed. No different than our federal government. If we're going to look at just in terms of parallel analogy, we elect government officials, senators and representatives, and a president who make decisions for our country on structural improvements, what have you. Same with the condo board. The condo board will hire or terminate employees, and of course the board can adopt rules. So what are the rights? I put this in quotes because it's not stated as such in the Condo Act, but I'm pulling concepts. If I had to say what rights do owners have, well, they have a right to know how their money is being spent. That can be related to B, which is the right to inspect records of proper request. Any unit owner under the state statute or the City of Chicago condominium ordinance can request books and records of account by stating a proper purpose. And letter C is what I just described to you of the increase of assessments, a right to reject. So what's a board member best practice? Well, at the top of the list is board members should attend board meetings. While, of course, there's going to be conflicts if it's perennially a board member who does not appear at board meetings on a regular basis, it's impeding the board to have good participation from a board member, and it could affect votes, especially if you're a 5-person board. One person is always missing. So if you're not in agreement, it's a 2-to-2 vote. Board members should know their governing documents. That's where management and your attorney can assist you. You need to review your financial statements, understand the law, and communicate with the unit owners. Board member code of conduct. This is not a mandated statute or a legal requirement, but this is, in essence, could be summarized what individual unit owners and the board should expect of other board members. And I'm not going to read each of the slides, but you can see here, as a board member, you're volunteering. However, you're volunteering to exercise good judgment. You're volunteering to be honest and in good faith, to keep information confidential that's supposed to be kept confidential. You will conduct yourselves in a professional manner. You will support the majority, even though you may disagree, and the minutes will reflect that if you vote no on a vote. You need to support what the majority states. Obviously, you should not make defamatory or erroneous statements about other individuals, and the goal is to minimize conflict. Inherently, not all decisions need to be unanimous. It only needs to be majority, but discussions need to be respectful. And if you're on the board listening to this, you know what I'm talking about. It's the shrug of the shoulders of a board member who's trying to disrespect somebody who's speaking because they disagree with the content of that speech. So what's a good best practice? Board meetings should be brief. There should be about an hour and a half at the high end. Some boards with the managing agent will get board packets. They will have proposals at their fingertips. They will have reviewed them before the board meeting. There will be discussion and decisions, boom, boom, boom. You need to have some semblance of following parliamentary procedure. Robert's Rules of Order is not binding unless it's incorporated in the bylaws, but there still should be a parliamentary procedure that the board adopts. Otherwise, there's a little bit of chaos when you're trying to discuss. There's no process. There should be an agenda, and there should be approximate times associated with it, and every board member has an opportunity to speak. There should also be a good practice, a time limit for a homeowners forum. The Palm 2 ruling. So I referred to this earlier in the slides, and if you've been on your community association or condominium board in the last few years, you probably have heard about from your legal counsel and your managing agent and industry periodicals the Palm case. The Palm case was handed down by the Illinois Appellate Court in May of 2014. And in a sense, the court was restating what was already the previous rules, but it was not really restating what was the practice. A lot of boards, in order to conduct business in today's day and age where they were not meeting as frequently as they used to before, handheld personal devices and email and iPads, iPhones, boards started communicating a little bit more casually, email, and they would discuss things where the unit owners would not be able to participate or observe the discussion. And they would come to board meetings and have decisions already made. And this case went up to the Illinois Appellate Court, and the Appellate Court was quite definitive in its rulings. So as of 2014, the law is no board workshops, no email voting or canvassing, canvassing meaning getting a sense or a consensus before the board meeting. Those are two things that boards have to live with. And I would point out that the Palm case talks about the board discussing, the verb is discuss, but that does not mean that the board and or managing agent cannot disseminate information. So the board members can still receive information about what they may be discussing at a board meeting. They just can't hit reply all and have discussion threads. They need to read it, come with their opinions, and discuss it in an open session. The court case also did say the board may delegate powers. It could be to an individual on the board, or it could be the managing agent. Of course, the person that the board delegates power to needs to accept that power, and the board is, of course, allowing somebody else to make the decision for it, so they need to understand what that means. And the last is more of a legal issue, which is exculpation clauses or indemnity provisions do not protect against gross negligence. So, open unit owner forms. This is basically a slide that you can read on your own, but it basically says if you're going to hold an owner forum, which is a good practice to communicate with your owners, this is a community, these are some good guidelines. Provide opportunities for owners to speak, but set time limits for questions, set time limits for the total time of the forum, establish some rules and protocols so you do not have shouting matches. Collections and foreclosures. This was the bane of existence for community associations at the economy downturn back in 2008. In today's world, the economy has gotten significantly better, and all management companies and community associations have seen a significant decrease in collections and foreclosures. That's good. You will still have some degree of collections, delinquent assessments, so there are some best practices. You should not allow delinquencies to linger on. 60 days after being delinquent, there should be a notice sent. And the association should turn over to its legal counsel accounts that are beyond 60 days. Keep a copy of the check or debit info. Why? Because if you ever get a court judgment and you need to collect, if you have the information of where the unit owner's money was written from, you can send a citation to discover assets to the bank, and if the money is still in that bank account, you get it sent to you. Bankruptcies, lenders, you just need to work with them and understand what your rights are. Payment plans are generally not recommended because if people are in financial hardship, they didn't have the money to pay in the first place. We have found over years of experience that payment plans generally do not work out for the benefit of the association because there's continuing defaults. If you are inclined to accept a payment plan as a compromise for a particular scenario, it's best to file the collection, the forcible action, get a judgment, and put the payment plan in the judgment, so if there's a default, you don't have to start the process over. You can go straight through. Foreclosures. The Illinois Condominium Act gives some rights to community associations in Section 9G to collect assessments in the event of foreclosure, but it's not the full amount of the debt owed. So you need to work with your managing agent and your legal counsel to ensure that the association's interests are being protected to collect the maximum amount. Also, last year there was a recent case that if a lender takes ownership of a unit and does not pay the assessments after the foreclosure is completed, and a ledger is sent to them, you can actually go back and collect all the unpaid amounts. So this was a recent case that is very favorable to community associations and in some circumstances allows the association to collect amounts that would otherwise have been not collectible. So what are the pitfalls? When you file an eviction action, you actually get possession of a unit. And for those rare times where an association goes through the process, the owner still does not become current, the association can actually lease out the unit. So that's only good for 13 months at a time. Don't take security deposits because you become a landlord. You must comply with the landlord-tenant ordinance. It's better to take fees. And make sure you have the ability to terminate the lease because if the debt is ever repaid, the lease goes back to the unit owner and you want the ability to kick out your tenant. And with that, that summarizes the presentation portion of the meeting.
We would like to thank you for your participation in today's webinar. We'd also like to thank Howard Dakoff of Levenfeld Pearlstein for this valuable information. As a reminder, this presentation will soon be posted on our website at liebermanmanagement.com. If you have further questions regarding governance or any other association matters, please contact your Lieberman Management Services account representative. Thank you again.